In the course of reviewing a revocable living trust, there are some notable differences between a trust that's created by a couple together versus a trust that's created by an individual. For purposes of this video, we're going to be reviewing a trust that would be created by an individual. So if you are a couple creating a joint revocable living trust together, please click out of this and review the other video that we've posted. For an individual, please proceed forward from here. Now, before we review the trust itself, a little bit of context. Trusts are lengthy and they're fairly dense documents. As a reminder, when we do estate planning, a trust is designed to last the entire rest of our lifetime, plus however long is needed after to carry out our wishes. So with that, we have to understand that trusts need to be written in ways that are flexible, that are accommodating. As we live our lives, or even after we're gone, assets will change, laws and taxes will change, the circumstances of our beneficiaries will almost certainly change. So we want trust to be written in a way that is accommodating so that those changes can be made later without the trust needing to go into a probate setting. So when you review a trust, what I want you to keep in mind is that the majority of the length, probably about half to two-thirds of that length, is going to be legal language and contingency language specific to the different things that can happen later. And we're going to cover all of that here today. But when you're reviewing a trust, most likely you're going to see sections that are called My Descendants Trust or My Beneficiaries Trust, followed by a section called Remote Contingent Distribution. These typically are going to be the last two articles that actually identify your specific plans, your specific people, etc. So while there are sections of the trust that are highlighted after this, I will encourage you, focus most of your efforts on the first third to the first half of the trust. And then anything beyond this is just going to be additional instruction and additional information for you. Now, going to the very beginning, when we create a trust, we own it. And at the time that we create it, we actually get to name it anything that we would like. And I would encourage you to think of a name other than your name. Trusts as entities are private. There is no public database of them. There's no registration with the Secretary of State or anything like with the business. So when we create a trust, if we give it a name that isn't connected with us, that isn't conspicuous to us, we create an additional level of privacy that we don't have otherwise. The legal name of a trust is what's underlined. It is the trust, dated the date ultimately that you're going to sign. So the draft that we give you, that date is going to change for the actual day that we ultimately sign. Now, a couple of notes. Number one, if you're creating a trust for the first time, you can change the name. If you're updating a trust that you already had, please understand you're going to be essentially stuck with that name. Two, the name of a trust, none of the names are taken. So as you choose, you can really call it anything that you want. It just can't be too long. So in between the words the and trust, if you would like to name the trust something else, and I encourage you to, please just let us know, write something down, and then we'll follow up with you if we need more information or if we think the name might be a little too long. Now, I will go through the actual substance of this trust directly, but there is a table of contents here. I recommend you start with the table of contents. It's going to help you identify the more important sections quickly. You can turn to them, you can review them faster than if you're just reading the document from start to finish. Now, going through the actual agreement. Article 1, at the very beginning, we are just going to identify legal structure of this trust. So first, I am creating this trust. I am called a grantor. I own this trust. I control this trust. This is my trust for the rest of my life. I am also the manager of a trust, called a trustee. Or as an example that I have here, maybe I'm going to be the trustee and I'll put somebody else in the trust with me to be a co-trustee. That's fine. But I'm going to own the trust. I'm going to manage the trust. For the rest of my life, this is my trust. But obviously, I will not always be able to make decisions. I will not always be here. So even when I've passed away, I actually still own the trust, which is kind of a strange idea. But the trustee after me is eventually going to change. The backup trustees are going to be listed a little bit further here in a section that's just called trustee succession. So 101, identifying my trust. This is the trust. This is the name of the trust. This is the date of the trust for all purposes moving forward. Reliance by third parties. When we create the trust, we're going to have it at all times, but third parties like banks and insurance companies, they're going to need some legal structural details about your trust so that they can understand how to properly set up accounts. They don't want to read your 30, 40-page trust, and you don't want to have to make a bunch of copies of it. When we have the signing meeting, there are a couple documents that we're going to provide you that are effectively one-page summaries of the legal structure of the trust to give to those third parties. These are commonly called certification of trust and trustee affidavit. So we're going to be providing those, and we'll provide you some additional instruction at that next step. Transferring property to my trust, I like to just answer the question here because I get it often. Why does my trust say that I am giving it $10? So one of the kind of minor legal rules about trust is that when we create it, we have to put something inside of it. So instead of itemizing all of your assets that we're going to be putting in here, and besides the fact that your assets are going to change over time, so we don't want to have to change the trust for that, it's easiest just to say that we gave your trust $10. You don't have to give us 10 more dollars. You don't have to take any further action. It is just a formality. Powers reserved. So you as the owner of your trust, it is yours. You own it, you control it. You can put things in, you can take things out. You can get rid of this trust if you would like. For the remainder of your lifetime, you're going to have that absolute control. Only you can change your trust. So after you are gone, the final version that's in place at that time is going to lock in stone, become what we call irrevocable, and then that's going to be the version that they take moving forward. And then finally, you're going to see a section called Grantor Trust Status. This is a really important tax provision. We're going to move assets inside of your trust. For the remainder of your lifetime, your trust is going to be tied to your individual Social Security number. For all purposes of income, capital gains, other taxes, that is going to flow through your trust. It's going to pass through your trust to you personally and go on your personal tax returns like it always does. Your trust has no responsibility to file or pay taxes until after you are gone. And at that point, it essentially takes over that responsibility. In Article 2, family information, we're going to identify any family. So there's going to be names and dates, etc. So just make sure that that data is correct. In trustee succession, we're going to be accomplishing two things. First is who are going to be those trustees after I'm gone or after I'm no longer able to serve, because I might still be here. And then second is going to be any number of contingencies and situations that might come up with the trustees later. We're going to be identifying some solutions, some processes now, so that we don't have to take the trust into probate if we can help it. So the first thing is there's going to be two sections of succession with the same people identified. So first is while I am alive, if I get to a point I cannot manage my trust any longer, who is going to step in after me and in what order? And then similarly, when I ultimately pass away, who is that list going to be? It's going to be the same list of people. So make sure that anybody listed, names are spelled correctly, people are in the correct order, or if you're still thinking about trustees, just identify for us ultimately who you're selecting here. Now, going back to the beginning, the rest of Article 3 is just some legal and contingency language. So resignation of a trustee. A trustee may not always want to serve or even be able to serve. So what would be the process if they wanted to step down from the role and for the next person to step up to that role? A little further down, unfilled vacancy. It is possible we could run out of every single trustee that you have listed. So in that situation, how do our beneficiaries get another trustee installed? Appointment of co-trustee. The trustees that you put in place, they're not required to do everything on their own. If a trustee wants, they can actually appoint other people to step into the trust as co-trustee to serve with them and to then help break up the workload. The co-trustee that gets appointed, they serve for as long as that original trustee serves. But once that original trustee steps down or passes away, then that co-trustee is going to end as well, and we're going to drop down to the next person listed. Corporate fiduciaries. So in planning, you might ultimately end up choosing to use a professional, a corporate trustee. If you do, this is just defining what that has to be, meaning it has to be a company, a bank, etc. It can't be a person, one of the heirs, and so on. And then incapacity of a trustee, this could apply to you or it could apply to future trustees. But obviously, a trustee may not always be able to make good decisions. And so if by accident or a medical issue, a trustee becomes incapacitated, this is a process that we go through to actually determine their incapacity and then remove them from serving in the trust. Appointment of an independent special trustee. Now, this is something that's very rarely used, but it's here if we need. There might be circumstances where we have to appoint another trustee for a very special purpose. So an example could be maybe most of my plan and my assets are in Colorado, but maybe I own a commercial property in California that's being rented. And my trustees here don't want to deal with it and don't have the capacity to deal with it. So maybe they appoint an independent special trustee there to be able to manage just that asset. Or maybe we have to have a bit of an investigation to make sure that the trust was managed properly by the trustee. A special trustee could be appointed for that purpose. Again, this is pretty rarely used, but we want to make sure that it's available if the need should arise for the future trustees. Documenting change of status. So the basic premise here is verbal notifications don't work. If a trustee wants to resign, as an example, they have to do it in writing, and they have to provide that notice to the interested persons of the trust, like the beneficiaries. Notice of removal and appointment. This is something that's not very commonly used, but it could be. You might find yourself at a point that you don't want to manage your trust. You could be 90 years old and just say, you know, at this point, I just want somebody else to do it. And you could just put somebody else in place as the trustee, but you still own the trust. You still control the trust. So if you chose, you could remove that trustee. And this is just providing how you provide that notice. And then finally, prohibited trustees. So a little bit later in the document, we're going to cover a topic that's called a special needs trust. It's a highly technical structure that gets utilized in order for somebody to be able to receive basically disability benefits, but also receive this inheritance. One of the key rules of that is the person who's in that special needs setting cannot serve as trustee under any circumstances. So this is just reiterating that. Now, two articles, administration during my incapacity and administration upon my death. These are going to work hand in hand, kind of chronologically for us, to instruct the trustee on what we're going to do with the inheritance before it gets to the next place in line. So first, while I'm here and healthy and living my life, I'm just going to do whatever I want. This is my trust, this is my property. But if I get to a point that I can't make those decisions any longer, if I am incapacitated, the important thing to remember, this is still my trust. This is still my money. It's still my property. So first, distributions for my benefit, trustee, you're going to step in and you're going to collect all of this and you're going to manage it for me. However, distributions for benefit of dependents, I might have people that are legally dependent on me. Maybe I'm married and my spouse is relying on this. Maybe I have kids that I'm still taking care of. Maybe I have an adult child that's disabled. So if there is somebody that's legally dependent on me, the trustee can also use my money to take care of them. And then finally, guidance for making those distributions. It's just providing a little bit of clarity to the trustee about how they go about actually distributing income and principal under those two ideas, under those two articles or sections. Now, Article 5, chronologically, okay, what happens when I pass away now? Before we move inheritance, we need to wrap up some final affairs. So number one, the trust, as I mentioned, the final version of it, whenever I pass away, that's the final version. The trust at that point becomes irrevocable. It's going to obtain its own tax identification number. It's going to assume responsibilities for my taxes, et cetera, after I'm gone. Payment of expenses and taxes. We just need to make sure that all of that gets wrapped up first. So trustee, make sure that you file and pay my last tax return. Make sure that you cover my cremation costs and so on. Excluding life insurance. So one of the benefits of life insurance policies is that when we pass away, that money is actually legally protected from any creditors that may try to come after me from collecting against it. By law, life insurance cannot be used to pay debts. So this is reiterating that statute here. And then finally, payment of death taxes. This is something that's not likely to apply for a couple of reasons, but death taxes refers to estate taxes. Now, right now, federally, there is an estate tax exemption, meaning the amount of money that we can leave before those taxes would even apply. And that number is very high. It hasn't gone below $5 million per person since 2011. As of this video, it's actually $13 million per person, but it changes. It goes up and down year over year. So this is simply providing, should there be an estate tax issue, trustee, here's how you go about handling that. Here's how you go about paying them. But barring that situation, most people, by an overwhelming margin, are never going to have any estate tax issues. Now, after this, if you have them, one of the things that you'll see in this article, specific distributions and disposition of personal property, you might have something here called a specific gift or a specific distribution, the same thing. A specific gift is when I'm going to take either a set dollar amount, such as $50,000, or some specific assets I own, such as my house or my car, and I'm going to distribute it somewhere other than to my main beneficiaries. So maybe I want to give $10,000 to this charity, everything else goes to the kids. Or maybe my sister gets my house, but all the other assets go to my cousin. So if you have a specific gift, I want you to just take a look at the language. If you want to provide any additional details or instructions about the purpose of the gift or how it's to be used, we can absolutely do that. Gifts are optional, by the way. Second, if you happen to have any pets or might have any pets in the future, we may have a discussion about the plan for those pets. If we're gone, we want to make sure our pets are taken care of. We want to make sure the right people or the right organization takes them. And then a lot of people give consideration of a gift of money to that person for the future costs of that pet. Some people might do a fixed dollar amount, maybe $1,000 for a cat, $5,000 for a dog. Other people actually will structure annual gifts that get distributed out until that pet has passed away. It doesn't particularly matter, but we want to take care of our pets. So if you have any thoughts, if you have any additional instructions to provide, please let us know. The last concept here is when we do planning, we're going to move assets into this trust, and they're going to be held and managed and distributed based on what the trust says here. The other thing we need to just kind of keep in mind is that we also have a lot of stuff. We are a culture of people that likes to accumulate. And one of the challenges that trustees are really going to have is when we pass away, what do we do with all of the stuff? So with this, there is a concept that's going to come up called a personal property memorandum. And I'm going to give you a template of that as part of the estate planning documents. The personal property memo, it's going to come to you as a Word file, Microsoft Word file, and it's really just a document full of blank lines. And in that, you can identify items and what to do with those items. There's two things that I recommend you consider here. So first is, what is important? This is usually, honestly, a handful of items, but I maybe have a family heirloom that I want going to a specific family member. Or maybe I don't care what happens with the item, but I have something valuable. Maybe I have a $10,000 piece of artwork and I want to make sure that it doesn't get sold at a garage sale or donated. Important things are important, so we need to write them down. But the other side of this coin is everything else. To the extent I am gone, what are you going to do with all of my blankets, all of my DVDs, all of my furniture? Generally speaking, we don't have to itemize every single thing that we have. Your document would be 50 pages. But what we can do is group things together and provide our trustee with some general guidelines. My own personal memo, I have about a page and a half filled out. Most of that is line items of things like all of my blank, do this. All of my furniture, sell it. All of my books, take them to the library. All of my clothing, donate it here. You don't have to be overly complicated, but I can tell you there's a lot of effort and a lot of energy and a lot of frustration that comes from having to dispose of all of our stuff. So I encourage you to fill out your memo and then just return it to us. And if you have any questions about filling it out, please let us know. Your trust as it's written first says, if I make a memo, then that is my instruction. Trustee, you follow it. However, the next section, distribution of remaining property, if I don't make a memo, or maybe I forgot to include certain items in that memo, trustee, I'm giving you the power, I'm giving you the discretion. You make the decisions after I'm gone. Now, the most important section of your trust. It's typically going to be called my descendants trust or my beneficiaries trust, but it's going to provide the plan. How is everything going to be divided and held and managed and distributed for my heirs, for my other beneficiaries, for the charities, whoever is involved here? Now, this is the one section where there's going to be a lot of differences from client to client. I'm going to show you some sample sections that are in here, but you may have any number of additional things. Some people include a section about trustee guidelines, where they're actually instructing their trustee on some specifics of how they want money being distributed out and what it's going to be used for. Other people, we might have something called a right of first refusal. If I'm leaving 2 or 3 children my house, maybe one of them would want to buy the house from the others. So what would be a process for them to be able to do that? So very commonly, the first one we're going to see here, when we leave behind inheritance, something that most people include by default is what we call a marital agreement. Our purpose in creating this inheritance, this legacy, is that it goes to the people that we want to go to. We don't want spouses of our beneficiaries to obtain any legal rights to the inheritance, because in the event of something like a divorce, that would cause the trust to get dragged into a divorce, and that spouse could end up getting inheritance that was never intended for them. So to prevent that from happening, we build in a restriction, a rule basically, that says beneficiary, in order to get this inheritance, if you're married, your spouse has to sign off giving up any right, claim, or title to the inheritance. It doesn't affect any of their other assets, any of their other income. It just protects this inheritance. So it's a really valuable provision to have. When we have younger beneficiaries, we often need to think about bad situations that could happen, unfortunately. So one of those that we like to cover in some amount of detail here is what happens if there's any drug and alcohol addiction issues. The trustees who are serving, we just want to give them some extra guidelines, some extra teeth in being able to respond to that situation. So if this applies to you, if it's in your document, take a look. If there are pieces you wanted to add, if there's anything you wanted to take out, please just let us know. We're happy to modify this. Another common situation for younger beneficiaries is what we call gainful employment. In the most simple terms, your trust is not a golden ticket. So if you are gone, the beneficiaries who are inheriting from you, they have to do something with their lives. They can't just sit back and expect that this trust is going to take care of everything for the rest of their lives. So take a look at this. If it applies to you, there's a number of examples of what constitutes them doing something. Now, if you have children under the age of 18, you are very likely to have a section in your trust called a common trust. If your children or beneficiaries are all adults, then this isn't going to be there. But a common trust, when we have minor children, we need to make sure that those kids at all times have 100% access to the inheritance, because each child is going to have educational needs and medical needs and living expenses and all of those different pieces. And we don't want a child to be penalized with less inheritance later because they had more needs as a child. So the solution to that is we create something called a common trust. And the idea behind it is I'm going to take everything that's left and I'm going to pool it into one pot. And while any of the kids are still under the age of 18, they're all going to have access to that one pot. But once they're all adults, whatever's left there, it's going to get divided up into equal shares for each beneficiary. And then into the future, they're only going to be drawing from their own separate inheritance. So this common trust language is just going to provide some of the rules about how that works. It's pretty simple, but if you have questions about it, let us know. And as you'll see at the end here, the common trust is going to end once all the kids are adults. In the trust, regardless of whether you have a common trust, there's going to be a section about how everything that's left over is going to ultimately be divided up. Now, sometimes the language is really simple like this one, and it says, everything that's left is going to be divided into separate shares for my descendants, which is defined previously in that Article 2 in that family information. But it's going to be divided into equal shares for my descendants, and then it's going to keep flowing down the family line from there in a structure that's called by representation. So by representation is just the English version of an old Latin term that attorneys used to use called per stirpes. And the basic premise of it is I'm leaving my money and my property to you kids, let's say. But if one of you kids were to pass, if you still have something in this trust, I want that to flow down now to your children, to my grandchildren. So we want to keep money flowing down through the family. But if my child passed away and didn't have any children, well, then it's just going to now shift over to my other child and keep going down their family line. That's an example of how this is going to work. The other way that we might structure this, if we're not just leaving things directly down to children, then we might actually have a list of people here. We might actually have identified beneficiaries, whether it's friends and family, charities, etc., and then the percentages that we're allocating to them. So if that's the case for your trust, just make sure that that language is correct. It's the correct beneficiaries in the correct percentages. Now, following this, how will we administer the different shares set up for the different beneficiaries? And again, your trust may have different language because you might even have different rules for each different beneficiary. But generally speaking, we're going to cover a couple of topics here. Number one, first, distributions of income and principal. How is our trustee, after I'm gone, how is the trustee going to make decisions about when and how the money gets distributed out to my beneficiaries? I might keep it pretty conservative and just let the trustee decide that. But I also could add in some qualifying language like you're seeing here in annual right of withdrawal. Maybe I'm going to include a section that says starting at a certain age, the beneficiary gets to take out a certain percentage every single year. Or maybe I'm going to put in a provision separately that says once my beneficiary gets to a certain age, they become the trustee. And now they get to make those decisions for themselves. So there's different ways that we can structure this based on what our intentions are for each of our beneficiaries. You're typically going to see a standard termination clause, and it's going to provide the circumstances in which we're telling the trustee to end a beneficiary's share. So an example would be if they ran out of money, if they used all their inheritance, well, their share is going to end. Or what happens when they pass away, etc. And then finally, at the end, there is going to be a section that's providing the flow of inheritance once a beneficiary dies, if they still have money in this trust. So a common example It's just going to keep going down to the children from them and the children from them, etc. Or I could say something like, well, if this beneficiary passes away, I want it to go to the other beneficiaries that I listed. Or I could even take it a step further and say, if this beneficiary passes away, I want the money to go to somebody brand new who I didn't even list before. So whatever the details are, just make sure that all of these sections of this article are in line with what your plans are, what your goals are. Now, after this, there's going to be one final substantive section. It might be somewhat short and simple like this one, or it might be a little bit more complicated. This is called remote contingent distribution. So when we pass away, it is possible at some point after that every single one of our beneficiaries have also passed away. And if there's still something in this trust, we need to identify the backup plan for where it goes. So first, this section, this language that you're seeing here, this is the default. What it says is if I'm gone, then I want everything to go to my next of kin. However, if I don't want that to be the plan, if I don't want the money and property just to go to my family, the other way that we can set up remote contingent beneficiaries is to say that I have these specific beneficiaries that I'm going to name in the trust that I want to receive as at these specific percentages. So maybe if we're all gone, I'm going to name some friends and some charities and all of that to receive everything. Whatever the situation for yours, just make sure that it's in line with what you're trying to achieve here. Now, Article 9 of this trust, what will be called distributions to underage and incapacitated beneficiaries of your trust. This is the one article that I'm going to tell you out of the entire estate plan, I recommend that you don't read. The language in here is highly technical and very dense. What it's doing is preparing us for a few different situations that might happen for how the trustee can respond to that so that the trust doesn't run into any significant problems or that our beneficiaries don't run into any significant problems. If a situation comes up, we've covered it. But if a situation that's listed here never happens, we're never going to use any of that language. So the first one, and what is absolutely the most complicated one, is a special needs trust. So it is entirely possible that a beneficiary, when we've passed, that they may end up in a disability or a special needs circumstance. And in that, they might look to qualify for something that we call needs-based assistance. That is in the category of things like Medicaid or Social Security disability. In order to receive those benefits, I have to meet certain financial thresholds. And the problem that we have is your trust is going to cause them to not qualify for benefits. So the solution here, and it's a very lengthy solution, is we can actually take a beneficiary share and we can restructure it as a special needs trust to allow them to simultaneously get their benefits, but also get access to this inheritance. It works fantastic. It is commonly used, but I'll tell you, it is just highly technical language. We can't change this. We need it to stay the same. So I'll just give you that overview so you don't have to read it yourself. Now, 902 and 3, this is dealing with a different situation. What happens if we have beneficiaries that themselves are incapacitated? Maybe not special needs, but incapacitated. Well, how do we do this? How do we work with them? How does our trustee distribute to them or pay bills on their behalf, etc.? So 902 and 3 is just providing some structure there for what that's going to look like if there's a beneficiary who's technically considered incapacitated. And I'll tell you, people who are underage, who are minors, they're legally considered incapacitated. The last part of this article, retention and trust, this is dealing with kind of the fallout from those prior sections of how we manage these specific concepts while that money has to be held in a restrictive way for these people. So again, if any of this applies in the circumstances that follow you, we've covered them. But if they never end up applying, we'll never use any of this entire article. Now, after this, trust administration is going to have just a number of miscellaneous sections. So at the beginning, what's highlighted there, the whole purpose of doing estate planning is to avoid the probate court. So this is simply providing an instruction to the trustee. You do not have to have this supervised by a judge. Distributions to beneficiaries. So very simply, once the trustee distributes the money to the beneficiary, it is theirs. And the trustee doesn't have to follow up and investigate and make sure the money was used in a certain way or anything. Once the money goes out, it's the beneficiaries, they can do with it whatever they choose. Beneficiaries status. So the trustee is going to operate on the status quo until they're notified differently. So for example, a beneficiary, they are going to be considered single until they tell the trustee that they got married, just as an example. Majority control, when we have two or more trustees that are serving, they're going to make decisions by a majority vote. So if there's two trustees, obviously it's going to be a unanimous vote. But if there were three trustees, two out of the three would be able to make decisions. So this is just providing that kind of decision-making structure for them. Delegation of authority. I always tell people trustees are not required to do or know everything. How could they? So if a trustee is serving, please understand as needed, they can delegate both their powers and any responsibilities for the trust to third parties. It could be, for example, delegating responsibilities to a financial advisor to manage the investments. Trustee exoneration. When we have trustees that serve in order in succession, we just need to make sure that one trustee doesn't become responsible for the decisions of a prior trustee, because it was that prior trustee. And if there were any problems with those decisions, it's that prior trustee's responsibility. Trustee compensation. This is just opening the door that a trustee can ask for reasonable compensation for the time and effort that they spend carrying out this trust. Now, compensation first, it is optional. A lot of times I find that trustees who are family members and close friends, they don't ask to be compensated. The other side of it is compensation. It is a process. It's heavily regulated by our statutes. So there are rules and checks and balances and processes. So sometimes trustees just simply don't want to deal. But this is opening the door that they can be compensated. And if they do ask for that, they're usually then going to follow up with somebody like an attorney or an accountant to help them structure that. Exercise of testamentary power of appointment. Now, it's highly unlikely you're going to have this in your trust. But if you do have a power of appointment that's built in, we need to have language in here that says how people can use it. A power of appointment, it's a power that you give to a beneficiary of your trust that allows them to make changes to the flow of inheritance. So as an example, my parents have a power of appointment for their trust. And they did that for a reason because several of us don't have children. So we get to decide when it comes down to us, after we pass away, where does the money and the property go, since there's not very many grandchildren. So you don't have a power of appointment. I don't typically recommend them except in circumstances like that, because powers of appointment can weaken some of the legal protections of our trust. But if one ever does exist, the trust is just identifying here how your beneficiary can actually use the power that was given to them. Otherwise, if you don't give them the power, this is not going to be applicable. Determination of principal and income is just a reference to a much bigger statute. When the trustee is serving, there might be questions that come up about how to qualify finances within the trust. So there is a law that we have as to how trustees are going to determine what is maybe the principal of a trust versus what is taxable income of a trust, and what are their options to deal with those taxes. Authority to terminate. The trustee needs to have the ability to terminate a trust if there's no longer any value, and if it's no longer practicable to keep the trust. So this is just explaining the circumstances when that might happen. And then lastly, we have a section called reports, or trustee accounting sometimes. And the trustee that's serving, they fall into a category that we call fiduciary. As fiduciary, there's a number of duties that govern what they do and how they do it. Probably the most important of those duties is that trustees are required to be transparent. They have to keep immaculate records, assets versus expenses, income versus debts, any compensation that's paid, taxes, and so on. So when the trustee is serving, they have to keep those records. And then by law, they actually have to distribute information to the beneficiaries on a periodic basis. So this is just providing basically an itemization of those rules. You, as the first trustee, do not have to follow this. This is your trust. You own it. You can do whatever you want. This only applies to future trustees after you. Now, my trustees' powers is going to be a lengthy article, and it's going to be very similar in scope to that first power of attorney, that financial, the general power of attorney. When we have a trust, we need to ensure our trustee has the authority to manage every conceivable asset and issue that might come up in this trust. Several of these will apply to you. Several of these may not apply to you and may never apply to you. But we want to keep the language in here because if your circumstances change and you end up having any of these issues or assets later, we need to ensure the trustee can manage them. So at the beginning, of course, is just an introduction. Execution of documents. Very simply, your trustee can sign any documents that are needed to carry out the trust. Investment powers. One of the fiduciary duties of your trustee is actually a duty to invest. And so this is giving them just kind of a blanket authority to be able to manage your investments and take things and invest them. But they're always going to be subject to those rules, those duties. Banking powers, your trustee can manage checking accounts, savings accounts, certificates of deposit, and so on. Business powers, if you have any ownership interest in a business, even a minority share, your trustee then can step into your shoes, assume control over that ownership, and manage it. So this is just providing some of the rules about that. Contract powers, your trustee can sign contracts. They could sign a listing agreement to sell your house, as an example. Digital assets, when a trustee is serving, we need to ensure that they have the ability to access and assume control and protection over anything digital for us. That could be anything as simple as an email account, a Facebook account, all the way up to income producing things like if I, have a software license that pays me money every month. Farm, ranch, and agricultural powers. Should you ever have any land or property interests that would fall under this category, we're just giving the trustee some additional specific powers, such as the ability to, farm out your land. Insurance powers. When the trustee steps in, they're going to have absolute control to be able to manage your insurance, obtain any insurance for you, or cancel any insurance that no longer applies for you. Loans and borrowing powers is one that we commonly get some questions about. So there's two ideas here. One is that the trustee can essentially take out any loans on behalf of you/your trust. The other being that the trustee could loan money to people. People could borrow from you and then pay that back. So why would we keep these? Why would we have these provisions? When we might have needs in the future. So an example would be maybe I am in an illness situation and I need to purchase an expensive piece of medical equipment. Maybe it doesn't make sense to drain my bank account or liquidate investments. It might make more sense just to take out that purchase on a loan. So the trustee could do that. In response to that, some people might say, well, I don't really want them to be able to do that, but I do want them to be able to manage my existing loans and debts. So we could change this provision if you want to. On that other side of loaning money to other people, I get clients that'll come in and it might be parents who regularly loan money to their kids and then the kids pay it back. So we could continue that process here, or we could get rid of that language. So whatever is applicable to you, we can modify this as you're going to need here. Nominee powers is something that rarely comes up, but there are certain assets that legally have to be placed in the name of the trustee rather than the trust itself. So like an example is in Nebraska, You can't own a property inside of your trust. The trustee actually has to own the property in their name on behalf of the trust. Kind of a strange and specific distinction. But we just need to make sure if an asset requires that the trustee have it in their name, that they can. Oil, gas, and mineral interests. If this ever applies to you, we just need to make sure that the trustee can manage any mineral interests you have. Obviously, if you don't have mineral interests, then this isn't going to apply, but we still want to keep the language in here. Payment of property taxes and expenses, pretty self-explanatory, but they can obviously pay your property taxes. Qualified real property valuation. So your trustee essentially has the ability to go through a process. It's under the IRS code for a special valuation of your real estate interests. It's something I've honestly never seen utilized for this purpose, but it is there. We want to make sure they have the power to do it. Qualified tuition programs. So 529 accounts are special types of accounts that are created for minor children to be able to pay for future educational bills on a tax-free basis. So in order for a trust to be able to take an interest in a 529 and become the custodian of it, the trust has to have very specific language built into it. So we want to have that language in here just in case for any reason your trust becomes involved with a 529. Otherwise, legally, it cannot manage the accounts. Real estate power is somewhat self-explanatory again. Your trustee can make any decisions necessary regarding all of your real estate. Residences and tangible personal property. So a couple of things. The trust can actually take a beneficiary's inheritance and use it to purchase them a house. So if a beneficiary needs one, the trust can actually buy the house for them rather than just giving the money to the beneficiary and they go buy it. And then the other thing is going to be the trust is going to have all your personal possessions. It can not only purchase, it could also liquidate or exchange property that might produce income. So an example might be maybe I have a bunch of vehicles and I rent them out to people and it produces income. So the trustee can obviously manage those moving forward. Retention and abandonment of property. The trustee essentially doesn't have to hold on to things that aren't producing value or income. So there's a couple of kind of qualifiers here about that, but they just need to have that power. And then securities, brokerage, and margin powers. This is really just all related to different types of investments, making sure that they have the power to manage those specific types of investments. And settlement powers, lastly, the trustee has the ability to just settle any claims or issues that come up. Let's say there's, a tax debt and they want to settle it and compromise with the IRS, they can do that. Now, the final section of this article is a limitation on powers. So there's a few pieces here, but what this is doing is distinguishing between two types of trustees. An independent trustee is a third party who is not going to inherit from you, who serves as trustee. Because they're not going to inherit from you, they don't have a conflict of interest, and so they can just do whatever is needed to carry out this trust. Obviously, then, an interested trustee is somebody who will inherit from you, and that creates a conflict of interest because it might cause them to want to manage the trust in a way that's more beneficial for them versus anybody else. So if an interested trustee ends up stepping in, we need to place some limits on what they can do and how they can do it to minimize that conflict of interest. So that's what we're covering here. The other piece is with respect to trustees. One of the things that we need to make sure of is that the trust can't be used to take care of any of the trustees' legal obligations. So there's a limit here that just basically says, trustee, you can't use my trust to pay your debts and obligations. Now, at the end, we're going to have some general provisions. So at the beginning, maximum term for trusts. As I've mentioned before, trusts can last a really long time. So in Colorado, once the trust becomes irrevocable, meaning we've passed away, the trust can then proceed for up to 90 years. You are never going to use that window of time. but you can use as much of it as you need. So this is just referencing for the trustee. This is how long the trust can go. In other states, it can go even longer. Spendthrift is a very important legal provision. The idea behind it is nobody can come after my money to pay your debts. So when I pass away leaving this trust, it's going to become irrevocable. I actually will continue owning it even though I'm gone. Again, kind of a strange concept. But what that means is for my beneficiaries, nobody can come after this trust to pay their debts and obligations. It basically puts a bubble around the inheritance and it gives them substantial legal protections. So it's one of the really beneficial things that a trust does for us. Contest, a very important section as well. When we have a plan, that is our plan. And we don't want people having any opportunities to fight or to try and undo that plan. So contest is a provision that basically acts as a penalty. You are going to inherit from me. However, if you happen to take any of these things that are listed, if you happen to do any of these things here, that is going to cause you to lose your inheritance. We don't want people being able to go into probate and litigate over a trust for 5 years. It takes so much time, it costs so much money, and at the end of the day, it's usually likely to end up bankrupting the inheritance. So, contest essentially says there can be issues that come up, and you can proceed through things like mediation in order to resolve your issues without causing this. But if somebody does go into court or they take any of these other actions that are listed, they're going to be stripped of any roles that they have, they're going to be cast out, and they will lose every penny. Contest is authorized by state law, and it works 100% of the time. As soon as somebody finds out that they're about to lose everything, they're going to stop. They're going to come to the table, and they're going to sit down and figure out a resolution, even if they're not happy about it. Survivorship is a kind of a technical issue. We don't want the trust having to be administered multiple times in a short window if people tend to pass away within a short window. So, an example, let's say I am with my beneficiary, we're in a car and we're both in an accident. Well, let's say I pass away. I don't want my trustee having to go through the whole process of buttoning up my trust and getting it moved to my beneficiary, only for them to die 2 weeks later. So we set a time threshold here of 30 days, which is a pretty reasonable amount of time just to make sure if somebody passes away within that window, we don't have to try and get the trust over to them. We then just move it past them to wherever the next place is. Changing the governing law in situs. So trustees, when they're administering this trust, they don't have to come to Colorado. They don't have to manage it here. They can take it elsewhere and manage it in another state. So this is just providing them the opportunity to be able to do that. There is a very lengthy definition section towards the end. I want you to review it. It is a few pages. Reference each term as you need. And then the final section, general provisions and rules of construction. This is kind of just a contract term, but it's basically how do we read this document. So the first section, importantly, is remember, we're going to sign an original version of the trust. We'll get that over to you, but a copy is just as effective as the original. So you can hand out copies, you can email copies, etc. And then the second one is you are creating all of this under the laws of Colorado. That's just identifying where it's being made and that it's being made validly here. And that's honestly, there's a couple remaining little contract provisions at the end. Now, in reviewing the trust, please don't feel like you have to do this all in one setting. I recommend take some time. You can break it up over a couple of days. If there are any provisions for you specifically that weren't covered in this video, or any issues kind of above and beyond that that you have questions about, by all means, please feel free to reach out. We can provide you additional clarifications here. And then ultimately, just make sure that you write down notes, write down questions, write down changes, and get those back to us. I will encourage you Refer back to this video as much as you need because it's going to help you as you keep reviewing and to retain that information over and over rather than trying to constantly get additional answers on our side, just because timing and staffing isn't always easy to do that. So you keep us posted. Good luck with it regardless, and we'll look forward to hearing from you soon.